How's it going, everybody? In this video, we're going to be talking about Miller v. Becerra, also known as California's assault weapons ban case. So let's talk about this. But real quick, before we jump into this video, if you think that California's assault weapon ban is completely unconstitutional and violates the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to give a big shout out to one of the main sponsors of the channel, and that is Franklin Armory. Franklin Armory is an amazing company. They have 3 California compliant AR pistols that you can currently go out and purchase from them, as well as they have other products out on the market that benefit people in free states. So Franklin Armory is just an amazing company. They've shown a lot of support to this channel and to what I do on this channel. So go over to their website, go over to their social media accounts and show them support. So Miller v. Becerra, this is one of those highly anticipated cases in the state of California, and it is currently waiting for a hearing before Judge Benitez or St. Benitez in the Central District of California. Many of you are familiar with Judge Benitez because he is St. Benitez. He has already given us many favorable decisions in the Duncan v. Becerra case, which we'll be talking about here in this video as well, the Rody v. Becerra case, and he has really just been that patron saint of California gun owners. And so Miller v. Becerra deals with California's assault weapons ban language and structure here in the state. I'm not going to comprehensively talk about the statutory language here in this video, but just understand that California has a structure and a statutory code language that prohibits certain types of rifles and certain types of firearms from being possessed because they are considered assault weapons. Now, that is not my terminology. That is a legal definition, and that is how California defines these type of rifles. For example, a semi-automatic centerfire rifle that has a detachable magazine cannot have a specific number of offending features on it, or else it is considered a assault weapon in the state. For example, like a forward pistol grip, a flash hider, a collapsible or telescoping stock, a pistol grip, things like that. If you have those on that type of firearm, it is considered an assault weapon. So that is what we're dealing with in Miller v. Becerra, and that was what this case is all about, is challenging that specific language, that specific California structure. And what the plaintiffs here in this case are seeking is a finding by Judge Benitez and by the courts that California structure prohibiting certain firearms under the assault weapons ban language is unconstitutional and violates the Second Amendment. This case was pending for a long time, and we were actually supposed to get a hearing in this case as of March 19th, I believe is what it was. It actually got pushed back a few times, and Judge Benitez was very graceful to the defendants in this case and pushed back the case a few times, but it was supposed to be heard early this year. But when the COVID and virus outbreak started, all the courts shut down, and this case pretty much got pushed back indefinitely, and we have no firm date yet of when this case is going to be heard, but we have had some development in this case, and I want to talk about that. And the update in this case is essentially that the plaintiffs here in this case have put forward Duncan v. Becerra, or the 3-judge panel decision in Duncan v. Becerra, as additional case authority for what they are seeking, which is a preliminary injunction on California's assault weapons ban language. So this might get confusing for some of you, so I'm going to try to break this down as simple as possible. We have Miller v. Becerra, which deals with the assault weapons ban, and that is still pending a hearing. The plaintiffs here in Miller v. Becerra want a preliminary injunction on California's language banning these specific type of firearms. That's what this whole case is about. It's about seeking a preliminary injunction. Duncan v. Becerra, or the Freedom Week 1.0 case, dealt with a challenge against California's magazine ban language. That has recently made its way up to the 9th Circuit, and we actually had a 3-judge panel decision which found that California's magazine ban structure was unconstitutional and violated the Second Amendment. So we have a decision by the 9th Circuit 3-judge panel in Duncan v. Becerra and in that magazine ban case. The plaintiffs here in Miller v. Becerra are now using that case decision and that ruling by the 3-judge panel in Duncan v. Becerra as additional support for why Judge Benitez should grant their preliminary injunction on California's assault weapons ban language. So this is interesting because you have the Duncan v. Becerra 3-judge panel decision being used as support in this case. And we were all anticipating that stuff like this would start to happen. And that's really what's happening because we've been getting a lot of favorable rulings recently. You may start seeing these domino effects where one case decision is used in another case. And that's really what we were hoping with some of these positive decisions. And that's what we're seeing here in Miller v. Becerra. And so I'll just read to you real quick what the notice says. Essentially, it's a quick blurb of notice that they are putting forward this decision in Duncan v. Becerra as support in this case, Miller v. Becerra, and then they also attach the 3-judge panel's decision in Duncan v. Becerra as an exhibit. So I also put a link down below in the details if you want to read this for yourself, but I'll just read it for you real quick if you don't want to go look for yourself. And so the notice reads, "Please take notice, the plaintiffs offered the following relevant new persuasive 9th Circuit authority, which was decided on August 14, 2020. And then they state that this was well after the briefing because briefing has already been finished in Miller v. Becerra, but this was a significant Second Amendment case that has come after the fact. So they are putting it forward as additional evidence, as additional support for their preliminary injunction that they couldn't have put forward before because briefing had already pretty much closed and his case decision hadn't come out yet. In their memorandum of points of authorities in support of the motion for preliminary injunction, page 10 through 16, plaintiffs contend that California Roberto Roos Assault Weapons Control Act of 1989 unconstitutionally bans firearms that are in common use and ideal for both self-defense and malicious service. Plaintiffs further contend that California's assault weapons ban language does not fall within any historical permissible limit on the right to keep and use arms, and also discuss the proper standard to be applied for firearms ban. In Duncan, the Ninth Circuit applied the strict scrutiny standard and held that the large capacity magazines were in common use and not dangerous and unusual. Therefore, the ban on large capacity magazines violated the Second Amendment. The Duncan decision supports plaintiffs' position that 1. Semi-automatic centerfire rifles, pistols, shotguns, and other firearms with various features are in common use and per se not dangerous and unusual. 2. Assault weapons bans are not long-standing regulations and do not enjoy a presumption of lawfulness. 3. The state's assault weapons ban is a categorical ban that fails strict scrutiny. And 4. If intermediate scrutiny is applied, the state's ban still fails and is unconstitutional. Notably, the Ninth Circuit also acknowledged that it is aware of the criticism of the two-step test appears to be entirely made up and that its application has yielded analyses that are entirely inconsistent with Heller. So here essentially what they're saying is we have this 3-judge panel ruling in Duncan v. Becerra. Pretty much everything that we've put forward as support here in this case, Miller v. Becerra, of why this assault weapons ban language is unconstitutional because it bans firearms that are not unusual or not dangerous, they're in common use, as well as the type of scrutiny that should be applied here. Also, they're saying that the assault weapons ban is a categorical ban, and also they state that even if you use intermediate scrutiny, this type of ban would still fail that standard. So they're saying all the things that we are contending here in Miller v. Becerra was pretty much found legitimate in Duncan v. Becerra in a very similar situation. And therefore, they are using the Duncan v. Becerra decision as support here in this case. Now, is this going to sway Judge Benitez? The reality is Judge Benitez has shown he is very Second Amendment friendly. And in all reality, Duncan v. Becerra and what the 3-judge panel said in Duncan v. Becerra was simply upholding what Judge Benitez already said down below. The 3-judge panel in Duncan v. Becerra pretty much just springboarded off of what Judge Benitez said there in that case, and it was all of these things. So it is unlikely that he were to deviate from that type of logic in a very similar case and even a more high-profile case that is more dealing with core Second Amendment issues because it deals specifically with firearms themselves. So this is definitely good because we've got some recent movement in Miller v. Becerra, and so this might signal that we're going to start having this case ramp up more, and hopefully soon we'll get a hearing date. So I'm definitely excited for Miller v. Becerra to develop more, and I can't wait for a hearing to actually be scheduled so that we know when potentially we might get another Freedom Week in regards to specific rifles and firearms. I know a lot of us are really anticipating this case. We were really anticipating it at the beginning of this year, but it's got pretty much pushed back indefinitely. If there's any update soon about the hearing dates or anything like that, I will definitely let you know. And also, as that starts to develop, I will put out another video kind of discussing how you can maybe get prepared for a positive decision in Miller v. Becerra. Now, it's hard to anticipate what exactly that type of ruling will look like, what you may or may not be able to do, but we'll cross that bridge once we get there or when we get close to a hearing date. So if you like this video and you'd like to support the channel, one of the best ways to do that is join the Patreon page, and I'll go ahead and put a link to the Patreon page down below. Also, just like, commenting, subscribing, and make sure you hit the notification bell because that helps the channel analytics, helps us spread the word about the Second Amendment, and also helps spread the word about what we are dealing with here in the state of California and what we are doing to fight these things. So as always, thanks guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.